persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to the oral argument session here at the 5th District Court of Appeal. I've been introduced. I am Judge John Harris. On the panel with me today, Judges Boatwright and Kilbane. We have one case on the docket today. Each side's going to get 20 minutes to present your argument. Appellant can reserve as much of that 20 minutes as you would like for rebuttal. We'll set as default, we'll set it at 5 minutes, but if you want something other than that, that's fine. Just please let me know. If you have any cell phones or other noise-making devices, please go ahead and turn those off at this time so that we're not interrupted. And keep in mind the proceedings are not only being recorded, but they're being broadcast on YouTube. So at this time, appellant, if you are ready, you may proceed.
Good morning, Your Honors, and may it please the Court. My name is Andrew Greenlee, and I'm here on behalf of the appellant, Ms. Janetta Scott. 5 minutes for rebuttal is fine.
Very good.
Your Honors, this is not a hard case. We know from Publix's own policies that the placement of a yellow caution cone means that there is a spill. And once the spill is cleaned up, Publix policies require that the caution cone be removed. We know from the testimony of Ms. Brittany Swainston that ice falling out of a ice chest cooler onto the anti-slip mat is a common occurrence. We know that the spill remained there for more than 30 minutes because the video shows no one cleaning it up. And
how do you know there was ice there?
Well, we don't know that there's an ice chest cooler. We're relying on...
You just said the spill was there for at least 30 minutes. How do you know that? Did you see that? Can you see that on the video?
Well, the spill, we know that there is, when they do come to clean it up, they use a large amount of paper towels. And the gentleman who cleans it up puts the paper, there's probably 15 or 20 paper towels. He puts them on the ground, uses his foot to kind of clean them up like that. And it's a large spill. So we know from the video that it is a large spill because it took in the 5 to 6 feet between where she was and the ice chest cooler.
I guess back to my question, how do you know it was there for 30 minutes? That was your statement. You just said it was there for 30 minutes.
We know at the time that she fell, there was a large spill. We know that. And that we know there's no evidence of how it came onto the floor. So there is an inference. If no one is there and you don't see anybody, for instance, I can picture a scenario where someone spills milk, you see it on the video. You see the origin of the spill. So we know at the instant that she fell, there was a large spill because it took a lot of paper towels to clean it up.
And the only way you know that, it sounds like, is because you're supposing that the quantity of paper towels to clean it up, that's where you get you're categorizing it as large. I'm trying to understand where you're getting that.
Okay, well, we see him clean up the area all the way from where she fell, all the way over to the ice chest cooler. So I would characterize that as a large spill, just based on the size, the area that he cleaned up. I would characterize that.
But you don't know what he's cleaning up. You don't know if he's just wiping the floor. Is there testimony in the record or something that indicates what he was cleaning, or if he's just wiping up the floor? Maybe there's a scuff. I don't know.
Yeah, well, Ms. Scott testified that it was, I believe it was her husband, who testified that it was the equivalent of 2 cups of water that were spilled on the floor. They testified that it was muddy, which indicates that it was there for a long time. And let's recall, this is summary judgment, so we can't weigh the evidence. We can't say, I just don't find that testimony credible. You have to accept it for the purposes of summary judgment.
Even if it's contradicted by the video?
Well, it's not contradicted by the video.
But if it was?
If it were contradicted by the video, then I think I would guess that the video would control. But again, it's not contradicted by the video. What the video does show is cleaning up, again, from where she fell all the way back to the ice chest cooler. So it's logical to infer that that's where it came from. That's the source. After all, there's a caution cone there. The caution cone, again, from Public's policies, it wouldn't be there if there weren't a spill.
So your client testified that it was really muddy. I had mud all over me. I watched the video. I can't see that. Were you able to see that from the video?
I wasn't able to see.
Maybe the video surveillance isn't the best quality, but
It's not the highest quality, and two responses to that. Number one, she's wearing dark clothing, so it might not be evident from her clothing whether or not there was actually mud on her. But the second response to that question is you don't actually see the water on the floor at all in the video. But we know that it's there because somebody comes there with a paper towel and he's wiping the area up. So we know that. We also know, by the way, that there is this electric cart that's there. It stops in front of the ice chest cooler. I watched a video this morning. It looked like it was around a minute that it stopped in front of the ice chest cooler. It kind of starts, stops. It looks like she's looking for something. And then it goes and it passes directly in front of Miss Scott where she fell. So all of those things suggest to me that, and let's not forget that it was their position on summary judgment that it was this thin trail that was coming from the cart that is what caused her fall. Well, if that's the case, it's reasonable, and in fact, it's the most reasonable inference that when she stopped there was a puddle there, she tracked it, and the puddle, we know that the puddle was there for 30 minutes because there's a cone there for more than 30 minutes, and the cones, according to Publix's own policies, it has to be removed once the spill is remedied.
Wasn't that cone, I think the testimony was, it varied a bit, but 12, 15 feet away from where
Nope.
the appellant fell?
No, it was 5 to 6 feet away. That's in the record on page 1018, the testimony of Brittany Swainston. And it's cited, the full question and answer is cited in the reply brief. So I'm not sure where this 10 to 12 feet away comes from. There was somebody else who testified that it was that far away. But again, we're here at summary judgment. So it is 5 to 6 feet for how we decide this case. It has to be 5 to 6 feet.
Okay, and what's the relevance of the policy? You keep indicating that the fact that the cone was there and it's their policy, which it seems like it does, to remove it after a spill. What's the relevance of that here?
The relevance
Of the
is,
policy itself, sorry.
Right. So the policy itself, it's strong evidence from which a jury could infer that there is a spill right there at the ice chest cooler. That's where the cone is. If there weren't a spill, then they would have removed the cone. So again, a jury is allowed to draw inferences, and in this case, a jury could easily infer, look, there's a yellow caution cone there. That means that there's a spill there. He cleans up right by the caution cone. That means that there's a spill there. I'm struggling to think how this is somehow a difficult case. This is only summary judgment. We have to, the presumption should be if there's a material dispute of fact, you just let the jury decide. We're not asking this court to direct a verdict in favor of Ms. Scott. All we're asking the court to do is to allow her to have her day in court and present her case in front of a jury. So this is not a case where it's, there's no evidence of negligence. There's strong evidence of negligence. Imagine for a moment that it's true that there is a caution cone and it's there for more than 30 minutes. There's a spill there. Nobody does anything about it, even though Publix employees walk right by it, and that nobody does anything about it, and it causes her to fall. That's gross. It's not gross negligence, but it is quite negligent if you allow a spill to be there for more than 30 minutes and you don't do anything about it.
again, how do you know the spill was there for 30 minutes? Because of the sign?
Because of the caution cone. The jury could infer from we don't know it for a fact. And on summary judgment, you don't have to know it for a fact. All you have to do is raise an inference from which a jury could infer that it is the fact. And in this case, the existence of a caution cone coupled with the Publix policy, which says that spills, once the spill is cleaned, the cone has to be removed. So all we're asking the jury to do is assume that the employees complied with public policy, with their own Publix policies. And if the jury follows that inference, there's no way that we can lose on summary judgment because a Publix employee had to have placed it there in the first place. The spill was not resolved, and he never picked it up, so that means the spill remained there. And again, we see him clean up the area right in front of the anti-slick, the black mat that's in front of the ice chest cooler.
Well, counsel, you've indicated several times inference.
Yeah.
How do you not have an inference stacking problem here?
Well, two answers to that. There is no inference stacking. There's just inferences right along the line. One inference, public's policy says that, if there is a cone there, you can't, you have to clean up the spill and then remove the caution cone, right? So that's one inference. But the bigger point is that there is no prohibition on inference stacking under federal law. We know that from the 11th Circuit, and it's right in the rules of summary judgment now, Rule 1.510, that federal law governs. So I know there is old soil here from the prior summary judgment standard, but that went away as soon as they amended the summary judgment rule. It's now governed under federal law. The law of the 11th Circuit could not be more clear. Judge Berger said it herself that there is no prohibition against inference stacking under federal law. And in any case, look, it's the right result. Every inference in a logical chain, you allow the jury to, if they could infer one, and then they could infer the next, and then they could infer the next, then the plaintiff can establish negligence. Again, I mean, this is not a case where there's no evidence at all of negligence. We have a caution cone, and we know from the public's policy that there had to be a spill there. If there weren't a spill there, there wouldn't be a caution cone there. And we know from the policies that once the spill is cleaned up, you have to remove the cone. So the cone wasn't removed. Therefore, it follows in a nice logical chain. There was a spill there. And finally, there's somebody who's cleaning it up, the area right in the immediate vicinity of the caution cone. So again, I've seen a lot weaker cases survive summary judgment, and in my view, that's what should have happened here. Let the jury decide. That's all we're asking. The proper role of the jury is to, find the real facts when there is a dispute. If we say that it's 5 to 6 feet away, and they say it's 10 to 12 feet away, then summary judgment's not appropriate. We need the jury to resolve these factual disputes. We could be wrong at trial, we could be right at trial. Our whole point is that this case should go to trial. It shouldn't be resolved on summary judgment because, again, you have strong evidence that Publix was negligent here. I honestly don't have any more to say. Unless there's any further questions, I'll allow my friend to speak.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Diane DeWolf for Publix. Your Honors, this is a perfect case for summary judgment. This is exactly the type of case where summary judgment is granted. The plaintiff has no idea where the liquid came from. She has no idea how it got there. She has no idea how long it was there. She really doesn't even know what it is. Premises liability under 7680755 requires actual or constructive notice, and she cannot prove that as a matter of law. That is what In Re Amendment said, that if plaintiff is required to prove X and she can't prove it, that's one way of getting summary judgment under the statute. We're talking about the cone. The cone didn't cause her to fall. We don't know why the cone is there, right? And we don't know that it was liquid, and we don't know that it was ice. A cone indicates a dangerous condition at some point. It could have been glass.
The cone put Publix on is that a constructive notice issue once they put that cone out?
No, it's not, because what the testimony is, and the deposition testimony is sometimes the cones get left there. We don't have any idea why the cone was there. The cone could have been, somebody could have been carrying the cone and got distracted by a customer and sat it down, because if you're in Publix, you ask a Publix employee for something, they take you there, right? They drop what they're doing and they take you to find what it is you need. It's possible nothing was ever there. It's possible something was there from the day before and somebody forgot to come back and pick up the cone. It's possible it wasn't liquid. If there was something there, it wasn't liquid or it wasn't ice. It could have been glass. It could have been a package of rice that got spilled. Who knows what it was?
Did one of the Publix employees even say there was water on the floor, though?
We do have some testimony that there was water where she fell, but that was not near the cone. And if you look at the video, you asked for the video, I'm sure you all watched the video, you can see she's on the very last aisle of the store. She's on aisle 16. She goes down there, she gets her beer, she comes back, The floor is perfectly clear. She turns the corner, and she falls in the front speedway. The cone is over on 16, past where the ice chest is.
Why would the employee be cleaning up in front of the ice chest then?
I disagree that the employee was, and if you watch the video, you might disagree also. The employee shows, and Brittany Sprainstein, by the way, doesn't remember much because she says, oh, it was all clean once I got there. Well, she's one of the first people on the scene, and if you watch the video, you'll see she's the one who goes back and gets paper towels and hands it to who she believes is Ron. Ron says, I'm not even sure that's me. I don't remember this at all. You see the employee, he takes the paper towels, he unravels them, he puts them under his feet, he walks around, he goes around the corner, he walks around. He was several feet in front of the ice cooler, ice chest, and several feet in front of the mat, and several feet away. If the mat was so wet that ice had then seeped out such that it could go around the corner and create 2 cups of mud, he would have been next to the mat. Somebody would have picked up the mat. So we also see, now,
Video
if
shows
this,
him wiping up the spill just a foot from the mat, right? Right in front of the cooler.
it was a couple of feet in front of the mat, it looks like to me, in the picture. He wipes and wipes and wipes in front of, not the ice cooler, he wipes and wipes and wipes in front of the cooler that's facing the front speedway. That's where he wipes and wipes and wipes. Then he turns around, and there's, oh, is there a spot there? Oh, is there a spot there? Now, also you can see from the video, you see, I think the testimony was 14 to 15 customers and employees going through the aisle. Not one, if there's all this water there that Publix never cleaned up for 30, 40 minutes, you don't see one of these customers or employees, slipping. They're on the mat. If the mat was so wet that it was gushing out water that's going to get around the corner, wouldn't one of those people say, oh, this mat is squishy? Wouldn't you see any of that in the video? You don't. You don't see mud. The husband said it was 2 cups of mud too, but then when he, in his deposition, did you see it? No, because her body blocked everything. If there was so much mud there, why were 2 customers right behind her trying to help her up? Why did Brittany Swainstein kneel down on the ground next to her before she got any paper towels? Clearly, you can tell from the video there's no mud there. The customers that were trying to help her were standing right next to her. And as far as stacking inferences, that is prohibited under Florida law, and nothing has changed since INRI Amendments was enacted.
Allowed under the federal rules?
I'm sorry?
Is it allowed under the federal rules, inference stacking?
You can stack inferences under federal law if the first inference is reasonable.
Have we adopted the federal rule for summary judgment?
We adopted the federal rule for summary judgment, but not for the stacking inferences. And Judge Berger clearly acknowledges that, and Judge Kilbane acknowledged that in her recent opinion of Leftwich v. Walmart. But in the Dix v. Coca-Cola case, who counsel relies on for adopting the federal standard, Judge Berger clearly says that the defendant comes in and says, no, you can't stack inferences under Florida law. And Judge Berger says, no, that's a procedural rule, so that's like a sufficiency of the evidence rule, and we're in federal court, so here we use the federal standard, and under the federal standard you can stack inferences if the first one is reasonable. That's not Florida law, and Judge Kilbane says that in Leftwich v. Walmart. She explains that if the first inference can't be to the exclusion of any other inference, you can't put another inference on top of that. And, not even plaintiffs' inferences are consistent with one another. She first says, it had to be the ice cooler, it had to be ice, that's the only possibility. Well, it's not the only possibility, because you can see on the video the lady in the little electric cart. You see her going down aisle 16, you don't see a little trail behind her. You see when she comes around the corner in the front speedway, you see this little trail. Now, is the trail dragging something? Doesn't look like it. It clearly is not. The trail is between her 2 wheels. It's not on either one of the wheels such that she's dragging something around the corner. And if the spill happened 40 minutes before, and there's so much stuff. I don't understand how she could get 2 cups of mud around the corner anyway, but if you look at the video, she's not dragging anything. It appears there's a thin trail, but it's directly between the 2 wheels, so it's not being dragged. It's either leaking or it's a figment of the video imagination. I don't know. They say the cone means there's a great big spill there. No, it doesn't. We just talked about that, right? It could have meant it was a bag of rice. It could have meant glass. It could have meant somebody forgot it the day before or hours before or set it there for no reason at all. Breaking Public's policy about picking up a cone right after a spill or not leaving a cone when there is a spill isn't what caused her to fall. Then she says, well, there were employees in the cooler, they had the door open for 10 minutes, so all this condensation, that must have gotten the mat all wet, and that's where the water... Well, the cone was there way before the employees were. The employees were in the ice chest like 9:45. She didn't fall till 10:30, and the cone was already there the whole time. So that's not what it was. And then, of course, they say the lady drug the liquid around the corner, which we know isn't true because she's not dragging anything because nothing's coming from her wheels. She wants you to believe that ice came from a cooler, that it sat there for more than 45 minutes, that they dragged it around the corner, that it suddenly turned into 2 cups of mud that caused her to fall. That's simply not reasonable. We do not ask juries to do gymnastics here to come to some sort of conclusion in favor of the plaintiff. There's just too many other possibilities. She doesn't know what it was. She doesn't know where it came from. She doesn't know how long it was there. She doesn't know who put it there. And this is a classic case for summary judgment. And if you have no more questions.
Okay, thank you. All right, you've got about 8.5 minutes left.
Thank you very much. Your Honors, my friend on the other side, she made some great points, but they sound to me like arguments for the jury. You shouldn't believe her, oh, it's unbelievable, it's not credible. We don't weigh credibility on summary judgment. We do know where the water came from. It's our position that it came from the ice chest cooler. That's been our position the entire time. That's consistent with the placement of the cone there. That's consistent with Publix's policy, and it's also consistent with the gentleman cleaning up right in front of the anti-slip mat. Now, placement of the cone, it had to have been a Publix employee who placed the cone there. A jury could infer that he did that because there was a spill in the vicinity. Now, there's no evidence of a bag of rice. There's no evidence of broken glass. She's inventing things. And if there is a dispute as to what caused it, then the natural course of things is to allow the jury to decide it. My friend said multiple times 2 cups of mud. Nobody ever testified about 2 cups of mud. It was 2 cups of water. Now, the water was dirty because it had been there for so long. But nobody said anything about 2 cups of mud. That would be strange. So it's 2 cups of water, and that's consistent with the large volume of paper towels that this gentleman used to clean up the spill. I mean, it was like that many paper towels, a huge clump. You wouldn't use that many if there weren't a large spill in the vicinity. It's undisputed that there was water on the ground. Publix employees testified to that fact. Now, because Ms. Scott, who didn't actually see the spill occur, because she doesn't know where the spill came from, if she said that she did, she'd be lying, of course. So the fact that she can't definitively say, well, it came from there, it's of no moment.
What is she pointing to when she's on the ground?
There's no volume, there's no audio, so it's hard to say. But it looks like she's pointing to the ice chest cooler. I mean, that at least a jury could infer that she's pointing back to the ice chest cooler, saying that's where the spill occurred. You see her point right back there, and then you see the gentleman in the other angle of the video go and clean up right in front of that. Again, that this is not a case of mental gymnastics. This is a straightforward negligence case where there's a caution cone there. And look, we can infer that it was accidental, that they somehow, Publix employees, just violated their own public policy. But you could also infer that they acted consistently with it. When there are those two competing inferences, we know that it's for a jury to decide. So yes, it could have been placed there accidentally. She can argue that in front of the jury if she handles the case. But we can also argue that the placement of that caution cone means that there was, in fact, a spill. By the way, the public's policies, they don't mention anything about broken glass. They don't mention anything about spilled rice. They talk about liquids being spilled, and that's why you have the caution cone. It also stands to reason that the caution cone would be required to be removed when the spill has been resolved. That's because it in itself is a tripping hazard. So it's natural that they would require somebody to remove the caution cone. Now, the caution cone wasn't removed, therefore, it's our position that a jury could infer that there was a spill there at some time. By the way, the public's policies also contemplate a spill starting in one place. They talk about you have to return to the site of the spill to make sure that it hasn't recurred, because sometimes you don't know what the cause of it is. Look, I mean, if we're going to speculate, maybe there was something underneath the ice chest cooler that, that created a recurrent leak, and maybe that's why the caution cone was there. We simply don't know, but what we do know is that there is a caution cone there that they cleaned up right in front of the anti-slip mat where the caution cone was placed. We know that there was liquid on the floor. It's undisputed. And by the way, Brittany Swainston, she testified that not only was it a common occurrence, she testified that, hey, we all just inferred that that the ice came out of the ice into the anti-slip mat. By the way, she did testify that there was ice there on the anti-slip mat. Now, she receded from that testimony slightly when she was, questioned about it. But she did initially say, yeah, we just all inferred or assumed that it came from the ice coming out of the ice chest cooler. Why? Because it's a common occurrence. So again, if it's a common occurrence and it occurs with such regularity that it's foreseeable, then they have constructive notice. So we have constructive notice that way. We have constructive notice due to the passage of time, which was, nobody's saying it's over 45 minutes, we're saying 35 minutes. And look, if it is 35 minutes, if we're right about that, and a jury could certainly infer that the presence of a caution cone means that there's a spill, that's strong negligence. Who lets a spill sit there for 35 minutes, and especially a spill that requires the volume of paper towels that it did to clean up? And the expanse from here all the way over to there to the ice chest cooler. Now, regarding the inference stacking, it's hard not to read Judge Berger's opinion as under federal law, there's no prohibition on inference stacking. We know that from Daniels, and we know that from Judge Berger's recent opinion. Now, I don't know, I haven't seen many Florida cases even address the issue, but I do know that we now follow the federal standard, and the federal standard could not be more clear. You're allowed to stack inferences as long as each individual inference, it's not just the first one, by the way, as long as each individual inference is reasonable, you're good to go. And these are very reasonable inferences. In fact, they're consistent with Publix's own policies. Your Honors, if there are no further questions, I'd ask the court to reverse the entry of summary judgment and remand the case for trial where it belongs in front of a jury. Thank you.
Okay, thank you both very much. This time the court is adjourned.